Before looking at a lasting power of attorney, firstly it helps to understand what a power of attorney is. A power of attorney is a legal document giving someone else power to act for you. Examples: whilst you're on holiday, you're selling your property. You set up a power of attorney, giving a trusted person, in other words, a brother or sister maybe, the power to act on your behalf. This could give them general powers over all of your affairs, or specific powers, e.g. the sale of your property. On returning from holiday, the power of attorney is terminated. What is a lasting power of attorney? This is a power of attorney where the person gives a trusted person power to act on their behalf, but only if they are diagnosed as having lost mental capacity at a future date. There are two types: property and financial affairs. Without a property and financial affairs power of attorney, your trusted person will not have access to bank accounts, etc. on your behalf. Health and welfare. Without a health and welfare power of attorney, it is not automatic that your wishes expressed through your trusted person will be taken into account. Just because someone is your relative does not give them any automatic rights. Who can be an attorney? Anyone you choose, providing they are over 18 and reside in the United Kingdom. Usually, up to 4 attorneys can be chosen. The power of attorney is set up, but it is not in force, as the person who set up the lasting power of attorney still has mental capacity. On recovery of mental capacity, the lasting power of attorney ends. Should it be required in the future, it can be reapplied. If the person setting up the lasting power of attorney never loses mental capacity, the power of authority never comes into force. Some reasons for loss of mental capacity: a stroke or brain injury, dementia, Alzheimer's disease, confusion, drowsiness or unconsciousness because of an illness or the treatment of it. What if a lasting power of attorney has not been set up? Access to bank accounts would be denied. The property could not be sold. Imagine that an alternative to going into a care home was to sell your property and put the funds released towards a larger house with a relative or an annex at their property. Also, you would not be able to rent out your property to generate income, but you would still be liable for upkeep and associated costs, without access to your bank accounts. But there must be a solution if a lasting power of attorney has not been put into place. Yes, there is. If you have no assets and only state benefits, your family can set up an appointship. The maximum total assets cannot exceed £5,000. If it does, you will require a deputyship. However, if you have assets over £5,000, the solution is much more complicated, time-consuming, and expensive. Complicated. Your family would have to apply to the office of the public guardian for a deputyship. Your family would have to prove that they are the best people to administer your affairs. Bear in mind that the office of the public guardian does not know you or your family. They have to safeguard against an estranged relative making an application. They could also think, if you really wanted your family to administer your affairs, why did you not set up a lasting power of attorney? Time-consuming. Usually 28 weeks, assuming the complex paperwork is correctly completed. Every mistake or ambiguity could result in weeks of delay. If there are multiple mistakes or ambiguities, This could result in multiple delays. Throughout this process, you, your family, have no access to your accounts or assets, compounding an already stressful time for them. Expensive. This would cost £940 plus VAT to set up. That is £1,128 plus for each deputyship, i.e., Property and Affairs Deputyship and Personal Welfare Deputyship, plus a court cost of £400. If a hearing is required, £500. Doctor's costs, an estimated £200. This depends on the area, but it is not covered by the NHS. Assessment of the person applying to become your deputy, £100, with the possibility of the deputy attending a course at added cost. A yearly fee of £35 minimum if managing less than £21,000. A yearly fee of £320 if managing more than £21,000. Providing certified accounts. This would depend on complexity, but a minimum of £100 per year. For a Property and Affairs Deputyship, potential cost around £2,200 plus in the first year, with annual cost of £320 plus accountant's fees. For a Personal Welfare Deputyship, potential cost around £1,900 plus. If you have both, then some costs do not have to be duplicated. Therefore, the total is around £3,300. It is dependent on complexity. Not only does the cost increases, but also the time frame. Throughout this process, you are still liable for the upkeep and maintenance of your property, but you do not have access to your bank accounts, increasing the stress and financial demands on your family. If you own rental properties, if you lost a tenant at this time, you would most probably not be able to re-let the property, as you could not sign a new lease. A lasting power of attorney can usually be set up for less than the annual fees of a deputyship. Providing the lasting power of attorney has been registered in advance, it becomes effective at the point of loss of mental capacity.